Good morning, good afternoon, and good evening, ladies and gentlemen. I welcome you to another episode on intellectual property by NISSMAT. The podcast today is going to delve into fascinating cases of intellectual property. We're exploiting the intriguing case of Boroline Antiseptic Cream, which is a beloved product in India, and its battle against counterfeit versions. We'll discuss the original design and branding. Despite not being registered, were protected under the Copyrights Act and the principles of passing off. Today, we'll dive into the compelling story of this brand integrity and legal triumph. To discuss the subject with me, I have the President of NISSMAT, Mr. C Pal Singh, and I, Pawanjit Ahluwalia, shall moderate the session. The subject that we are discussing is duplicate Boroline Antiseptic Perfumed Cream. And jumping off onto the first question or the first slide is what Boroline cream is used for and how one can recognize it at the time of purchase. Mr. C Pal Singh.
Good evening, good morning, and good afternoon, everyone. Thank you, Pawan, for giving me the opportunity to explain this very important case study, which was a little difficult for any enforcement agency or even investigating agency to go ahead and get the case registered with the police and ultimately in the court of law. Now, coming to the first question, what Boroline cream is used for? The Boroline cream is basically an antiseptic perfumed cream. It's a very, very popular skin cream, and all over the country, particularly in the rural areas, it is very, very popular, and the people just go in for this antiseptic cream, which is also considered to be a skin cream. Now, the special features, as well as you said, how can you recognize the special features of this particular cream is its design on the tube as well as on the packing and the color. It's a greenish color, and the typical design, as you see in the slide itself, that is there on the tube. Similar design is on the packing. And this design and specific style of words is only the recognition by which you can say that it is all right, it's a Boroline cream, and it is a genuine cream.
Something, nowadays with the advancement in the packing technology and, the way the style can be copied, with a naked eye, it becomes very difficult for a normal consumer who's illiterate on the product to sort of make out. With all this, there's still chances of him being conned.
You see, your question is very relevant. That is up to the manufacturer. I am talking when this was being produced as such. With the last 2 years, 3 years, they might have changed the design, I am not sure. But I am very sure that in case they change the design, they would have propagated it. Because they are, by virtue of this particular design, by virtue of just the particular writing, they are having a lot of economic benefit for years. So I am not sure as far as whether they have changed or whether it's very difficult to recognize. But consumer as such, just a rural consumer, I don't know about nowadays there are sophisticated consumers in the city, but a rural consumer just goes to the shop, chemist shop, and asks for a Boroline. And for that, he just sees that packing is that green color packing. the word Boroline is written on it, the design is there. Now, Boroline cream, actually, the most important part of this particular story, the case study which I am referring, that this particular even design, which you are indicating how can they, because we are not very difficult to recognize, this particular design even is not registered. Neither design is registered, nor is the literary wording on it registered. So the most unfortunate part of this case study was that this is absolutely was an unregistered under the trademark, as well as not possible to enforce under the Copyright Act.
Let's sort of move on. And now we just look at this particular slide which says unregistered trademark. And the question to you, sir, is now, is Boroline cream registered with the Trademarks Authority? If not registered, what type of legal protection is available to this cream?
Precisely. I mean, we are discussing case study, Pawan, as to what should be done. The manufacturer should have done like that, or it should not have been done. That is not the case. The case is, how did we face it? How did we face an unregistered, without registration with the trademark, without even its literary design being there so that we go to the brand protection? How could we get an enforcement action? Now the question is, this Boroline cream is not registered in the Trademark Act. The Trademark Act gives some protection under the law 1991, as well as there are also certain cases where we have no trademark registration, but we can get under the brand protection. Because we go by the literary wording, the literary design, and that literature sort of thing is actually the basic, that is a literature. So in this case, the problem was that neither it was registered under the Trademark Act, nor its literary artistic work came under the Brand Protection Act. So therefore, it was a very difficult sort of enforcement action to be taken by the enforcement agency as well as by the investigation agency. Now, the trademark and the type of legal protection is provided without the trademark register, unregistered trademark. The type of legal protection is provided to a group which is not having a literary design or under the action to be taken under the Brand Protection Act. So that was a difficult thing. Now, what is we said? We went and studied everything, and in consonance with studying everything, we thought that it comes under the meaning of passing off. Unregistered trademark, it comes under the definition of passing off. Definition of passing off and this doctrine of passing off and the law of tort is attracted in this case. Although Brand Protection Act is not attracted, although Trademark Act is not attracted, but so long we are able to have it, there's a passing off product, it will come under the passing off as well as under the doctrine of law of tort. So it is attracted. Keeping in view that it comes under the passing off and the law of tort, we went ahead with the enforcement action. Pawan.
I think that's a very good thing that we did. And now moving on to the next slide, this is talking of unregistered trademarks and passing off. Could you first explain what is passing off?
No, the passing off, there's no such thing as you call as explanation of the word passing off. But there is, under Section 28 of the IPC, Indian Penal Code, the word passing off is used. Though the exact definition of this, now I'll give you, which is now being applied, is by the Supreme Court. Now, in one case,
you're talking about the Supreme Court of India.
Supreme Court gave the definition, and it says that unfair trade practice, which is unfair trade practice, and also goes to say that the economic benefit of the product which is already in use by a particular company is made use of by some other one. So the economic benefit, and then is there's a particular definition. And third point is deception. Now this is very important, that there should be an element of deception. And I'll tell you very interesting case studies are there. In the case of deception, it's not necessarily that they are deceiving the manufacturer. The deception is also with the consumer. So they say, there are case studies, I'll come to that where the Supreme Court defined that this particular, the color is a little different, or the design is a little different, but the consumer is deceived. He goes as if it is a product, is the original product. So the word deception has been used under the passing off. And they say that passing off will actually come under these 3 points. There's an unfair trade practice. The economic benefit is being used by a company which is not manufacturing. The economic benefit and the reputation of somebody else is being used. And top of it, that there's a deception to the manufacturer, to the consumer. So under these processes, they have worked the word passing off. Now the passing off is straightway covered under Indian Penal Code also, Section 28 of the Indian Penal Code.
Thank you very much. I have yet another question. What legal protection is available to such products which do not have a registered trademark under the Trademarks Act of India?
You see, what legal, I have already discussed that all legal, under deception you come under passing off under 28, this comes to cheating. It comes under 428, for 420, earlier 420 IPC, now of course the sections are changed, but earlier 420, it would come under 28. So you can, and then you have only, there are certain things which have to be proved. You're all right. The code has designed, the Supreme Court has designed and defined, no doubt, the passing off. But what are the ingredients? That definition of passing off is applicable so long the ingredients which are indicated by the Supreme Court are applicable. In that case, the passing off will come. It will simply come under the Indian Penal Code Section 28 and 420. Simple. There's no need of a trademark. There's no need of a.
Now, what exactly are the principles, basic principles of passing off?
So I have already given, but anyway, since it's a sort of repetition, for the concept of passing off, we have to prove that the plaintiff, I say we have to mean the plaintiff has to prove, when we go on behalf of the plaintiff, has to show the reputation has been acquired by the plaintiff for years by just this on this product, on this design, on this particular item. And that reputation is as good. The reputation is as good as goods are normally provided in any reputed product which are under Brand Protection Act comes or which may come on a registered trademark. So therefore, the plaintiff has to show that it has acquired reputation, though it has not been able to register under the circumstances applicable at that time, but the passing of action is attracted in this case because the reputation which is earned and the benefit which is the principal employer has been, principal manufacturer has been getting, that principal employer now is suffering, the principal manufacturer is now suffering because of the duplication, that no one has any right. The third point, they said the Supreme Court definition that no one has any right to represent their goods as the goods of someone else who has been either registered or not registered. So long the goods are, and there is a deception, element of deception, it will come under the passing off. And a very interesting principle of passing off I'd like to explain to you in two judgments. The first judgment was in the case of HUL soap, Hindustan Unilever soap. The judgment of the session court was that it comes under the deception. And therefore, because the color, etc., of that particular soap and the duplicate soap are almost same, the covering was same, the wrapping was almost identical. So the judgment given by the session court was that it does come under the passing off. But the other party, that is the so-called duplicator, he went to the High Court. He says, sir, there is no duplication at all. You find that this color is a little different. If they have a pink, we have written reddish. If they have written the soap, this word, we have given italics word. And in case of wrapper also, we have got a different type of wrapper, though also the wrapper has indication just like the original product, but this has indication only, not in terms of just look. But otherwise, our wrapper is different. The High Court reversed the decision. High Court said that it does not come under passing off. And therefore, the plaintiff has no right to claim that this product is being sold by duplicator. It's their own product, the duplicator. Then the plaintiff went to the Supreme Court on the same product. The Supreme Court reversed the judgment. Supreme Court said, no, it comes under passing off. And how does it come under passing off? They say, so long this product being sold by the duplicate is deceiving the customer who is so used to that actual product. He is unpar. He may not be very educated to read all these words. But once he sees with the eye and that particular person feels that this is a particular soap of actual and it is purchased. So you are coming under that particular definition of deception. Under these circumstances, you come under the action of passing off. The Supreme Court, therefore, changed this particular decision of the High Court. In the other case, there was another case also, that was by Cadila Healthcare Company Limited. There are also unfair trading by which one party, through deception again, attempts to obtain an economic benefit on the basis of reputation of another person, which has acquired itself. It will come under passing off. In the Cadila case also, Supreme Court has said. So the passing off has been defined in various particular, I don't know, two particular cases where this has been defined as a passing off. And both the cases, the Supreme Court held that this comes under the passing off. So these are the various ingredients which are there by the Supreme Court. So we had these cases with us after study, that the cases are there. So though the case, this particular Boroline was not registered, yet we said that probably it will come under passing off. Now the further what problem arose, you go to the next slide, Pawan.
Okay, I just recap what you said. The requirement for legal cover under passing off are the plaintiff must prove ownership of the mark. He must show that the goods have gained popularity and reputation. So that would be in terms of the balance sheet and so on and so forth.
Yeah.
And reputation enjoyed should be similar to that of a registered trademark.
Registered trademark.
So you see, it's to show all these things, one has to have the quantum of sales that you are doing, the shops that you are your distribution system, and so on. So a lot of things, though the words may seem simple, but to prove all this, you got to put a lot of things together.
I'll give you a little explain further to you. You say, what is a registered trademark? A trademark which is normally registered with the Trademark Act under the government. An unregistered trademark is that which is not registered with the government, that is the Trademark Authority. Now, this is considered unregistered. One point is here. However, the owner can still, as I showed you, unregistered, I'm going one by one. The unregistered trademark owner can still use this unregistered trademark as it is protected by common law of torts. I told you again and again. As it is protected by deception. So although there is no action for infringement. There's no action for infringement under the Trademark Act. Yet the common law of tort and the passing off is applicable. As simple as that. So therefore, in this particular case, it was irrespective of the to be successful, however, in the court of law or before the police, the owner of the unregistered trademark has to demonstrate that this unregistered trademark has attained the goodwill and reputation which is like concerning this product. This product has obtained that goodwill and reputation for economic benefits, etc., to the manufacturer. So that is how it clearly covers an unregistered trademark.
So I think while this particular slide is talking about the Supreme Court definition of passing off,
I've already explained at length.
We have already covered this. So I'll move on to the next slide, which is renewal and validity of unregistered trademarks. And my question to you is, how can the owner of an unregistered trademark prove its value and goodwill over the time? We did touch upon it earlier, but just to sort of, summarize all the things, it will be nice to sort of just go over as to if I have to prove that I have value and goodwill, how do I go and prove it in court, or what is the material that I require for the court to be satisfied?
The books of accounts, the earning by this particular brand is easily shown. They say, all right, from this particular market, this much were earned. Total earning which has been done in 1 year is this. And what is the earning in one year and 2 years? That all gets to prove the value and goodwill of that particular unregistered trademark. The unregistered trademark do not need regular renewal. This is the other beauty of the thing. That means if you know exactly that you have a goodwill, if you know exactly that you can prove the value of your product, then it is better not to get registered, because unregistered trademark has to be registered again and again. Regular registration is required. For any registered registration, you need regular registration. After a period 2 years or something, trademark, I'm not remembering at this point of time, you have registered. But unregistered trademark do not need regular registration and renewal. So therefore, owner must only has to show the length and duration of the use and the market reputation. That is how it comes under the passing off and under the law of tort. And of course, if you want to apply, you can also apply Section 420, earlier Section 420, that is cheating.
Now, moving on to let's talk about the present case of the duplicate Boroline product. What was the problem and how did you go about solving it?
This is a basic question, which very, very important point. All the things were general. Okay, it has acquired a reputation. Yes, it has acquired a reputation. You prove it reputation by virtue of economic benefit. All right, this is deception. Yes, the particular purchaser has been deceived. But the idea was that this particular marking which is given, on which you have acquired this benefit, the particular plaintiff, whether this marking is yours or you have taken this marking from somewhere else, the one that color and the design, always not in the literary cover, but whatever there is, it is because you claim it as yours. Was it registered by you? Was it aesthetic or design any time produced by you? No, it was very difficult. This was the most difficult thing in this particular case study, where we asked the manufacturer of the original brand of Boroline that, do you have any proof that this particular, as it is, I'm not asking, is it unregistered? Okay, it's unregistered. It doesn't come under literary, under the benefit. Okay, it doesn't come. It does come under passing off. Yes, it does come passing off because economic benefit are there and deception is there. Okay, but how do you prove that the actual product is yours? It's not somebody else. Then he says, then what to do? I said, you have to give me something about the original design or the original artistic work or original your when you had produced this, when you had started this business. No, this was a very difficult company for the company. When they got the idea in discussion, they said, all right, our particular artist has been there. Although we have not changed, we have changed other cases. Try to understand. They were having so many other things, so the artist was there with them. So they went to him, and I think they could get some design and give it to me, which indicated that about 20 or 25 years back, that particular artist had given this kacha design and that sort of paper, which was got certified by the manufacturer. Yes, the design certification was given by the company that this is our artistic design, and certificate was once it was endorsed by the company, it was proved that it was yes, it was designed about 25 years back or 20, I exactly don't remember the years, and therefore this is their product. So first is prima facie, is it your product? We agree that is a passing. We agree that is a everything is there, deception is there, but is the product yours? So under these circumstances, it came to the conclusion, yes, the product is there because they had got this design manufactured. So on the basis of this particular certificate obtained from them, we were able to convince the prosecution that here it is, the identical duplicate product is in circulation in various areas of Uttar Pradesh. The pass of products under Section 28 of the IPC was attracted, and the Boroline cream, which was being duplicated in the market, that was seized, and we were able to have the investigation which revealed that a large number of shopkeepers, a large number of medical stores were selling duplicate Boroline cream to their customers. Then when the representatives of manufacturers also revealed that though the coloring and design, etc., of the wording was being followed by the manufacturer for a number of years, any registration at that time was not done. Although they were following for the last 20 or 25 the same wording, same word, but any registration either of logos and design or of coloring like the original product has not been done. A copy of such design printed on the tube of the cream and also on the wrapping was in violation, and it was a passing of act was attracted. So passing of and law of tort was attracted. So this is how we were able to get the case in the police and ultimately and got into the court of law.
Now, you see, for any case to be processed like this, it is very important for the manufacturer to prove that he has reputation and goodwill in the market. So, how
Right.
did our investigations help the manufacturer to sort of prove in court later that they have reputation and goodwill for this Boroline product?
Sir, I have already told you that that is for the company. They could got the book. I mean, what did the prosecution ultimately went to? As far as investigation was concerned, it came under a particular passing of and law of torts was attracted. A case was prosecuted. Now the question is that prove, as I told you, that it has been used for the last 25 years. That also was proved that the artistic design was there 25 years back or 20 years back. Now the question is, all the reputation, they say for the last so many years, we have been getting this benefit. And every year with this particular product, we have been having an increase in the benefit. So therefore, we are our economy is impacted, our product is impacted, and this is being impacted by a duplicator.
I also recall, you see, when we were doing this, you had gone around and taken certificates from various shopkeepers, taken their photographs that they've been selling this product for several years, and their sales of this particular product has been very high. So there was a lot of collation of data, which, as an investigation agency, that had been done to prove that the manufacturer was actually selling this product for a number of years, and he had a large distribution system, which went on to prove that he had reputation and goodwill both in the market.
No, this one case is all right. In case of Boroline Antiseptic, the proprietor was able to get certain evidence from the certificate from the designer, as well as economic benefit, as well as collation about how much circulation it was there in the market, how much product was being sold in the market. That collation had to be done. But in view of this particular difficulty which is felt in such cases, it is highly recommended that parties invariably should get the trademark registered, because it provides a definite protection under the Trademark Act. So prevention is always better than cure, because if you say we are registered under the Trademark Act, at least you are preventing your product under the Trademark Act. In this case, it's a very difficult case, and Boroline Antiseptic Perfume Cream, because it was very popular skin cream and was widely used in the urban and rural areas at that time, the specific features of the product, color, style, design, words used on the tube, as well as the economic loss incurred by them, and all this made it possible for us to get it to the court prosecuted.
I just like to point out to the audience that there are two types of remedies that one gets. One is through the enforcement action through the law enforcement agencies, which is detrimental to the product being sold in the market. But if you want to have an economic, if you want to recover your economic loss because somebody has been selling your product and passing it off as yours, there is an economic loss which has to be moved to the civil courts to recover your economic loss. I move on to the next slide. And was the legal action justified?
It is almost covered in the discussion. Legal action was justified on the basis of what was produced, what the investigating agency was able to get from them. Whether proprietor got this certificate and design correctly or not, this is not the job of the investigator. They gave us a certificate, and the certificate was duly validated by their own certification and their designer. So therefore, this was justified. But the only question which you are asking is that what was the justification for enforcement? And the justification does not mean that unregistered trademark has no protection. That is what I want to say. The justification is don't consider that an unregistered trademark has no protection under law. They were almost at a loss as to what to do. We don't have registration. It doesn't come under literary product. What to do? We have got actually a lot number of people who are duplicating. What to do? So those not registered can have the same right as registered trademark. That is what I am trying to say. So long it comes under the passing off. So long it comes under the doctrine of passing off and law of tort. So therefore, one side is a benefit, but it needs a lot of evidence and a lot of effort to prove it, because you have proved it in a way that is a passing off. But they had to give the certificate, they had to give that they were suffering economically. So therefore, this is both the sides. On one side, it is there that the principle, no one has the right to represent his goods as a principle. You talk of basic principle. The basic principle is that no one has the right to represent its goods as the goods of other reputed brands. Basic principle of any passing off or trademark or brand protection is that there is no one has the right to represent its duplicate goods or its goods as the goods of other reputed brands by using certain things here and there and trying to cheat the customer. So the remedies are applicable in various ways. One remedy is under trademark, one remedy is under the Copyright Act, one remedy is under 420 state way if they are able to prove, one remedy is under passing of Section 28. And therefore, the passing of remedy, this concept of passing off, that the plaintiff has to show that the reputation has been acquired. The plaintiff has to show normally that their reputed product has been earning them a lot. They are getting them a lot of earning. The norm of passing off is attracted only if there is a deception involved as far as the customer is concerned. The principle being that no one, I will come back to the same conclusion. The principle of all these things is that no one has the right to represent its goods or his goods or their goods as the goods of someone else who has been either registered or not registered or come under trading mark or under the passing of product, that judgments are there. So therefore, my submission is that this is a case which is not normal. You see, the action is to confuse the customer. The action was by deceitful use of a particular mark, a particular sort of picture, he is trying to pass off his products under that particular product of someone else. So
as the actual. So I think we run out of time now, and I thank you for the insights of this particular case study. And I'd like to tell our viewers that NISSMAT has an enforcement department that, and should you have any such cases which are harming your product, please feel free to contact NISSMAT, and we shall give you time to sort of talk to us and see as to how we can help you. I'd like to thank you all for joining us on the Intellectual Property Insight. The Boroline case highlights the importance of protecting your brand, even if it's unregistered. The successful defense against counterfeit products underscores the power of artistic work and reputation. Stay tuned for more stories on intellectual property and brand protection from NISSMAT. Until next time, keep your brand strong and your rights protected. Thank you very much.
Thank you indeed. Thank you, Pawan.